But first, breaking news. A federal judge has denied a request from Donald Trump's former chief of staff, Mark Meadows, to move his Georgia election interference case to a federal court. Meadows is charged with 2 counts, racketeering and solicitation of violation of oath. He argued his case should be handled by a federal court since his alleged actions were part of his duty to the president's office. A judge disagreed. Meanwhile, a different judge has unsealed the full report from the Georgia Special Grand Jury's investigation that sparked those charges. It recommended the Fulton County District Attorney indict 39 people. Ultimately, Fani Willis only brought charges against 19. CBS News congressional correspondent Nikole Killion has more.
According to the unsealed report, the special purpose grand jury recommended indictments for 21 additional individuals, including former President Trump's ex-national security advisor Michael Flynn, Georgia's Lieutenant Governor Burt Jones, former Senators Kelly Loeffler and David Perdue, and current South Carolina Senator Lindsey Graham.
I was totally surprised. I never suggested anybody set aside the election.
Graham was one of 75 witnesses subpoenaed by the jury over his calls to Secretary of State Brad Raffensperger, who claimed the senator asked him to find a way to set aside votes.
Senator Graham applied for us to audit the envelopes and then throw out the ballots for counties who had the highest frequency error of signatures.
Graham has denied any wrongdoing.
It's very clear that there were issues in this election.
Loeffler, who once called for Raffensperger's resignation, stated, "I make no apologies for serving my state," while the former president boasted the grand jury has zero credibility and wanted to indict anybody who happened to be breathing.
I don't expect anybody else on that list would be indicted.
Emory law professor Morgan Cloud suggests some of the individuals who weren't charged could be cooperating with the case.
You get the sense that some of them may be witnesses that are going to appear at trial.
In another major development, a federal judge rejected a request by former White House Chief of Staff Mark Meadows to move his case out of Fulton County to federal court that could have implications on other defendants, including the former president, who's considering a similar move. Christina?
Nikole Killion, thank you. CBS News legal contributor and Loyola Law School professor Jessica Levinson joins us now. Jessica, what do you make of the judge's denial to move Mark Meadows' case to a federal court, and did that surprise you?
It didn't surprise me, even though, as the judge acknowledged, it is a pretty low bar when it comes to removal. What the judge said here is essentially, I think you acted outside the scope of your duties. I think that you went beyond what is in the job description of a chief of staff, and you acted really as a political operative for the Trump campaign, which is inappropriate. It violates something called the Hatch Act. And it also means that Mark Meadows, according to this federal judge, is not entitled to removal. This has to be a fairly significant blow for him because he took the risk of taking the stand in this removal hearing and testifying for 3 hours. That testimony can now be used against him in the Georgia state case, which is moving forward.
Wow. And on this special grand jury report, what are some of the reasons a DA wouldn't have taken all the indictment recommendations?
So I think Nikole gave some great reporting here where it could be that some people are actually cooperating. I think the other thing for people to remember is that even though a grand jury recommends certain people be indicted for specific crimes, there is still a difference between those recommendations and a district attorney looking at, for instance, the vote breakdown in that grand jury and deciding what to do to move forward. District attorneys are well aware of the fact that they need unanimous verdicts. They need all 12 jurors to say proof beyond a reasonable doubt. And so in some of these cases, I think what you see is potentially 1 or 2 or more people not voting to indict on some of those crimes or for some of those people. And therefore, maybe a DA saying, you know what, this one is just too risky to move forward.
Is it possible, just because they haven't been indicted doesn't mean they can't, right? It doesn't preclude them from bringing charges later. And could we see charges, if a cooperating witness doesn't fulfill their duty, or could they be charged in another jurisdiction at some point?
Yes, and yes. So it is absolutely possible that we could see charges in the future. It is absolutely possible that in some cases that's because a witness was cooperating and then maybe that agreement fell apart, or maybe that witness simply stopped cooperating. It is also possible that district attorneys, to your question, in other jurisdictions are looking at some of these activities as well.
All right, Jessica Levinson, thank you so much for breaking it down.
Thank you.